So this would be the main access point going in, to where the pond is located on the property. Obviously, you have the concrete barriers up there, and then you have a no trespassing sign, and you also have what they call a dry fire hydrant, to where, like, volunteer fire departments, there's a fire in the area and they need to retrieve water. That's what that hydrant there is for.
All right, we're stepping away from this testimony from this witness who is expected to be one of the last witnesses for the prosecution in their case. Let's bring in our guest, criminal defense attorney and former prosecutor Josh Kolsrud is with us. Josh, so good to have you. This case is an unusual one for so many reasons, and one of the biggest ones is everything that's being talked about. All these investigators who are getting on the stand, they are recalling something that they looked into 24 plus years ago. That is a challenge in itself, but also that the crack in the case was not DNA, was not some change in terms of the physical evidence, but yet they have testimony from a best friend who came forward. Let's start with the cold case element of this. That can be really challenging for prosecutors. Can you talk about what things have to happen on the front end in a case like this?
Well, I'll tell you, cold cases are always tough. Witnesses' memories fade. You have to go over evidence again. And generally speaking, the crime scenes aren't fresh. So you're looking at the evidence as it was recorded, in this case, over 20 years ago. But on top of that, the prosecution, they felt like they needed to offer a deal, an immunity deal, to the defendant's former partner, because they felt like they needed corroboration, that their case wasn't strong enough without something else to corroborate what the witnesses were hearing on the witness stand. Now, what I mean by that is that, when you have any case like this, what you want is a witness to be believed. And a jury, when they hear that somebody has immunity, they don't necessarily like that. But if it is corroborated by the evidence, it does become very powerful. And in a case like this, it could be just enough to push it over the finish line.
I think those are really good points. So we have this friend, Stephen Gates, who opted today not to be on camera or have his audio recorded. There is a law in Ohio that certain witnesses are able to opt out if they want from being on camera. We were hopeful that we'd get to see this witness after 24 years telling the truth this time. There was a problem with things he said to police back when it happened in 2001, where he denied knowing anything about the disappearance of Regina Hicks. And then in 2015, there was also this questioning of him, a proffer. Everything in the proffer is not the same as what he said today. I mean, these jurors, do you think they need to hear from Paul Hicks in this case, or is he going to stay silent in all of this?
In my opinion, I think that in cases like this, it's important for jurors to hear from the defendant. The defense attorney needs to obviously prep his witness, his client, but a jury wants to hear why the defendant didn't do this from his own mouth. Because if you're charged with murder, especially something that is a cold case, they want to know why you didn't do this, not just from the evidence, but from the defendant's own mouth. So, I obviously he doesn't have to take the witness stand, and they can't hold that against him. However, their prosecution, I think, does have the momentum because of the immunity. If they didn't have that, I think that he could probably gamble and not do it, but I think that he does need to do it in this case.
Mr. Sayers, then, does the city have any further witnesses to present?
No, you are subject to the admissibility of the government's evidence of the state of arrest.
All right. And Mr. Rich, does the defense wish to produce evidence at this time?
No, Your Honor.
And do you wish to have any further statement prior to starting the hearing? Other than closing statement.
Your Honor, we'll take up the issues to discuss the chambers outside the presence of the jury.
All right, very good. The court then, at this time, upon the resting of the parties, would indicate that at this point you still can't discuss the case amongst yourself. You can't discuss it with anyone else. Okay. So we will see you at 8:45 on Friday.
And And there you have it. Court is adjourned. This jury going home. The defense not putting on a case at all. This jury, at this point, has not heard anything from the defense outside of cross-examination. Let's bring back in criminal defense attorney and former prosecutor Josh Kolsrud. Josh, I got to get your opinion on how the defense has handled this so far. The defense has presented everything. They even opted out of an opening statement, so everything rests on this closing on Friday.
You know, I was so surprised by what I just heard. It's almost unheard of that a defense attorney wouldn't provide any opening statement. Now, let me tell you why this is so important. An opening statement, it tells the jury like what you're framing the issues as. And as a defense attorney, in a case like this especially, you want to warn the jury about some of the evidence they're going to hear. For example, you know, the immunity, how old some of the witnesses' memories are going to be, and you know why they shouldn't believe everything that the state is going to throw at them. You know, juries want to hear stories. They want to make sense of all the evidence. And if you don't give them something, they're just going to borrow what the state is giving them, and that's the lens that they're going to be looking at the evidence for. Now, there are occasions where I do see defense attorneys doing this when they actually have evidence to put on, like their client is either going to take the witness stand or they're going to present some type of witness testimony. You know, I don't agree with doing the second opening in a case in chief because, again, I think that momentum matters, but that would be the time to do it. And if you don't put on any evidence and you don't do an opening, this is a game of chess. You just lost your queen, and it creates an ineffective assistance of counsel on appeal. This is huge, and this could be the case for the defendant because in closing arguments, right now, all the defense has is playing with logic and looking backwards, but juries don't make decisions based on logic. They want a story that fits right, that makes them feel good, and the prosecution has already given them the lens in which to do this. So this is huge.
Yeah, it almost feels like a white flag for the defense. Like they are just going to leave the state's case as it is in front of this jury. But of course, we are going to be hanging on every word of these closing arguments because that's the only time we're going to hear from this defense. I want to ask you one thing about the star witness, because really that's what matters. Do you believe Steve Gates or do you not? And when the defense cross-examined him, I know we couldn't record it, but just to give an idea to this, to our viewers about what was said, this was from the cross-examination. They asked him, here's something from the direct, and then I'll talk about the cross. I remember looking in the car, and I saw Regina crumpled up in the passenger side floor. Where was the defendant? Outside. Josh, in cross, they didn't come back and say there was any motivation he could have to lie. What do you think about that?
Well, you know, when you cross-examine the state's main witness, you have to have main points that you want to get across to hurt their credibility. And when you hear what you just said, you don't hear that they hit that point. And it sounds, and we know that this witness is material to the case. That is, that the prosecution felt that this witness was so important that they gave him immunity. And so, you know, as a defense attorney, everything is based upon what your cross is going to show in this situation right now. And they must affect the credibility as much as possible.
Yeah, Josh Kolsrud, thank you so much for all of your